Hi, everyone. My name is Mark Waker, and I want to welcome you to the Special Education Legal Clinic. This is the first ever, so thank you for joining us. And I'm here with Danielle Randolph. And Danielle, if you could introduce yourself, that would be great.
Absolutely. Thank you so much for joining us today. My name is Danielle. I'm the advocate with Albite Waker. I have a background in school psychology and special education administration. So learning the language is definitely my forte because I speak the language every day. So thank you again for joining us today, and I hope you learned something great.
Thank you, Danielle. And I said my name is Mark Waker. I'm an attorney with Albite Waker. And Albite Waker is in a collaboration with OCECD, which is the Ohio Coalition for the Education of Children with Disabilities, and Disability Rights Ohio to offer the Special Education Legal Clinic. And we do this on the second Saturday of every month, and you can attend in person or online. And today we are going to start with a workshop. This is the first in a series. And we continue every week with a different workshop, either presented by us or DRO or OCECD. And you see there on the slide that there's a registration link that's lawyersforstudents.com/legal clinic. And that's where you can go to register, find information about the legal clinic. We offer not only the workshop on those Saturday mornings, but we also offer individual guidance sessions, which are sessions one-to-one with an attorney or advocate, so that you can offer your issue, your special education related issue, and receive some direct guidance and feedback on the issue. And those can be scheduled for free, just like the workshop, at the link that's shown there on the screen. And one other thing that's at the bottom, once you go to the link or go to the website, lawyersforstudents.com/legal clinic, at the bottom, there's a resources page which we put together for parents. And that has lots of different special education resources. And the next thing we think which would be helpful is a research portal. So we have links to all the related laws, special education related laws that parents or guardians might need as they're working through an issue with the school or in the special education process. So a couple important things that are there in addition to the information about the clinic. All right, like I mentioned, this is the first in a series of 7 that Danielle and I are going to present. And we start with the basics. This is learning the language of special education. We call this the Power to the Parents series of workshops. And we're excited to get started. And I'll start. I have just a couple, a little bit of background information, which I think is relevant. I think it's important not to go too far into the legal aspect of what special education is, but I think it is insightful to understand where these laws came from, why states are obligated, why schools are obligated, and who they're obligated to. So without further ado, the first real foray into obligating states in special education was a law passed called the Education for All Handicapped Children Act. And that was in 1975. So not really in the grand scheme of things, not too long ago. And this was the first law that obligated states to offer special education for students with disabilities. So before that, it was, you could or you couldn't, or you did or you didn't. And if it wasn't in any way standard. There weren't rights that were ascribed to it. In that, there was a little bit of lead up into the Education for All Handicapped Children Act. And that was a couple cases that were decided. One was the Park case in Pennsylvania, which was ultimately a consent decree entered into between the school and the state. And that required that all children, through that consent decree, so as an agreement between the parties, that the school would provide a free and appropriate public education. And that's where that term comes from. We're going to talk a little bit more about that later. But so in that decree, the term FAPE came out of that, free and appropriate public education. And then in another decision, this was actually a court decision in the District of Columbia, it outlined what due process rights parents should receive. And that was the basis for what is now known as due process. So those two decisions in 1972 led up to the Education for All Handicapped Children Act, which was passed in 1975. And then the Education for All Handicapped Children Act was amended and renamed IDEA in 1990. And then that was reauthorized in 2004. So IDEA and IDEIA, the Individuals with Disabilities Education Improvement Act, together we refer to that as IDEA. And the purpose of those two things are the same, and that's to provide a free and appropriate public education that meets a child's unique needs and prepares the child for further education, employment, and independent living. And that phrase says a lot. I mean, and a lot of back and forth between parents and advocates and school districts is based on what is appropriate there. What's the appropriate education? And that standard has changed over time too. What's important to understand about IDEA, those two laws combined, is that it has very specific requirements for schools to follow for students with disabilities. So you enter into a contract ultimately with a child and identify specific special education and potentially related services that would be provided. And then parents have mechanisms then to challenge if those things aren't happening or if the school's not fulfilling its obligations under the contract. So 90% of what we will talk about in this series of workshops, including today, will be those obligations or the services that are available under IDEA. So next we'll move down to just a couple, I guess, less important in the grand scheme of things, but also important to know. No Child Left Behind, it does have an impact on what we talk about in special education, mostly because it requires highly qualified teachers in special education, and it requires measuring student progress and district progress, and they do that through assessments and data. So that does come into play and sometimes with special education, but that's where those, with standardized assessments, if you've heard the term for better or for worse, they came into play with NCLB in 2002. And then another thing that parents of children with special education may run into or run up against is Section 504 of the Rehabilitation Act or the ADA, two civil rights related laws. A little bit different than IDEA. IDEA has substantive obligations and due process rights and other rights for parents and children, whereas Section 504 and the ADA are civil rights statutes that prohibit discrimination based on disability. And those two laws, 504, ADA, apply generally to any federal fund recipient. So that could be agencies. In fact, we have a law firm here and we have to comply with ADA requirements for accessibility for any individual with a disability. So it is a broad-based law that applies across sectors, not just education. But you may run into a 504 plan, which is something that kind of an alternative to an IEP, which you get under IDEA. We're throwing a lot of terms out at one time, but they're coming. And a 504 plan is a plan of accommodations for a student that flows directly from Section 504 of the Rehabilitation Act. And just to give you a little context, Section 504 was really stemmed from, traces back to 1918 when it provided rehabilitation for World War I veterans. So it is a long-standing law, but it does have application to schools and not only to students, but also to employees of the school and anybody who might visit the school as an outsider. So accessibility for any individual with a disability. And then another one that I think is important to understand is FERPA, the Family Educational Rights and Privacy Act. This all relates to student privacy and records, confidential student records that the school maintains. really all you have to know about FERPA is it does three main things. First, it gives parents and students an absolute right to every single education record that the school maintains. If they have it, you can get it. You can request it, through typically through the school treasurer, but the data person, the records custodian, whoever that might be with the school. But it gives you an affirmative right to those records, including all special education records, evaluations, IEPs, 504 plans. And the second thing it does is it prevents the school from providing that information to third parties. So you have an affirmative right as a parent. Third parties are not allowed to access that. It makes it confidential. And then the third thing is a lot lesser known under FERPA, but I think is sometimes useful, is that it gives parents and students the right to request amendment of education records if the information is inaccurate or misleading. And the cool thing about that provision of FERPA is that you can request amendment, and if the school disagrees with amending, they're required to give you a hearing in front of somebody from the school who's a non-interested party in the outcome. So three main components of FERPA, all related to student privacy. So that's a little bit of background of the laws, and we'll talk a little bit more about the substance, mostly about IDEA, as we continue here. And I'm going to turn a little bit of this over to Danielle to help me out. So Danielle, if you want to start with what FAPE is and what that means, that would be great.
Yes, absolutely. Give you a rest. But that was some great background information. So I'm sure everyone appreciates that. So as Mark had said, under IDEA, really we talk about FAPE. And FAPE is a free and appropriate public education. And so a lot of the laws that we talk about fall under FAPE. And really, when we talk about best practices, what school districts should be doing, what they should be providing, again, it falls under FAPE. And this just means that special education services that are provided to a child who has a disability should be at no cost to the parent, and it should be appropriate to their needs. I liked the definition under IDEA that said unique, right? It should be individualized and specific to that child. So I would say typically when we have difficulties with a district, it's usually because of FAPE, because they either are not following FAPE or there are some different components of FAPE that we have questions about. LRE is the least restrictive environment, and this is a continuum of settings where services are provided. It may not be a necessarily physical setting, it typically is, but it could be, let's just say, a space and another space. But when we talk about LRE, we talk about what is the most appropriate placement for that child to allow them to access the curriculum with their non-disabled peers to the most extent possible. So for each child, this is going to be different. Their needs are going to be different. And it's not dependent on disability category, it's dependent on that child's needs. And again, it's a continuum. So a child may start, we'll just give an example. They may start in the general education classroom with very little supports. And that's really kind of on your least restrictive environment of the continuum. And let's say they start really struggling in math. And so as a team, we agree they maybe need some support in the resource room for math. Then you're kind of moving up on that continuum, giving them less access to the typical peers because you're removing them from that setting for math. But it goes all the way to the other end, which is homebound instruction. So that's really at the tail end of your continuum. But in between, that could be full resource room for services. It could be an outside placement. All those fall under the continuum. And a district is obligated to have supports and personnel to provide services in all those different areas on the continuum. So sometimes I run into a situation where a district says, we don't have the place for that. We don't have the personnel to service that. Whether we're asking, I would say typically it's because we're asking for a resource room placement for a child. And so in those instances, then we have to look elsewhere. Do we need to have an outside placement? Then that's going to be more supportive. Or do they need to hire additional staff? So don't ever let a district tell you they don't have the proper placements. If they don't have it, they need to find it or they need to offer it somehow.
Danielle, we do have a question, if you don't mind.
Yeah.
So the question was, how do you determine what's appropriate? Which is, I think, the question, that we're always trying to figure out. But I think I can offer, I at least can maybe start the answer here. And so, as an attorney, we're always just looking at the law, like how is appropriate defined? Like, what has the court said that appropriate is, or does the statute say what appropriate is? And so I guess the starting point was back in 1982, there was a decision from the US Supreme Court known as the Rowley decision, which the standard was that inappropriate education confers some educational benefit. And as you can imagine, some educational benefit, first of all, it's a little vague and it seems a little weak in terms of, what the school would have to do. Some educational benefit, that's the standard. So luckily it has evolved over time and the standard has changed and actually strengthened certainly in the last decade. Now they've gone on to say that there has to be some level of meaningful academic progress through the special education process, so through the IEP, and progress is what's important there. So meaningful academic progress, so the child is just not, toiling in mediocrity or not making advancements. The way we determine what's appropriate in each case, first of all, goes to the legal standard to some extent, but Danielle, you might be able to talk a little bit more about the, a case-by-case basis, what you're looking at when you're determining whether or not what the school is doing is appropriate.
Yeah, and Andrew F. in 2017, right? I mean, that's a lot of years in between Rowley and Andrew, where they said, oh, well, okay, maybe not the minimal. You have to do more than the minimal. So we made some progress. But yeah, I would agree. There's no definition for what's appropriate under IDEA or any state guidelines. It is up to interpretation, but it is definitely a case-by-case basis. And I think, Mark, you really hit it on the head. You look for progress. You want to look at those IEP progress reports. You want to talk to the school staff and see how your child is doing in school. Because if they're not making growth, or they're making very minimal growth, then their education is not appropriate. Their services are not appropriate. So we need to talk about what we need to do in addition to what they're already receiving to see some growth. My biggest hang up on the progress reports, though, is when they say adequate progress. And I'm always left wondering, what does that mean? What is adequate progress? So again, I still think that it is very subjective. And so you have to look for patterns. You have to look for that progress, and not just in one 9-week time frame. Long-term progress. Where has my child started and where are they at now? So yeah, that's a good question, but it's a difficult question to fight. That's for sure.
Yeah, I think it's important to point out too, because I always find this fascinating that, that not only when a student is placed on an IEP or identified as a child with a disability who needs special education services, obviously there are rights that go along with that we're going to talk about a little bit more. But what's interesting is that a child with special education actually has the ability, or a parent in child with special education has the ability to identify whether, through progress report, the IEP and progress notes, whether or not the child's making an educational benefit, and then hold the school accountable for that. Whereas, a child in the general education curriculum, if they're not doing well for any particular reason, or not making progress, or not getting good grades, and it's not related to a disability, you really don't have a mechanism to hold public schools accountable for that. You can put your butt in the seat and listen to what the teacher says and take the test, but that's about all you have in the general ed environment. But in special ed, those rights are powerful, and the tools that you have with an IEP are pretty powerful.
I was going to say, what do you mean the No Child Left Behind? Let's retain our third graders if they don't pass. That's holding them accountable, right?
Right.
So next we're going to talk about PRO1s, or prior written notices. Now, a prior written notice, this is something that I would say has evolved over the years. And every time you meet with a school district, you should receive a prior written notice. Even if no changes have been made to your child's IEP, you should still receive one of these, because this is the documentation that states what was discussed. I will say this is the district's account of what was talked about. And as a parent, you may disagree with some things that are in this form. Now, I have been in situations where we have disagreed with what's in the prior written notice because maybe we heard it differently, maybe we interpreted it differently, maybe we made some assumptions. And you can submit a written letter that says what you disagree with. However, you cannot have that. Well, you can request them to change the prior written notice, but they don't have to. Because again, this is the district's account of what has occurred. So just keep that in mind that you can ask them to make changes, but they probably won't, and they don't have to. They may, but they don't have to.
And
But
one
you
thing
should,
I wanted to
yeah,
point out, Danielle, sorry to cut you off, but
that's fine.
I put this sample form up here so everyone could see it. This is Ohio's form, and they call it a PRO1, which is their form of prior written notice. But not every state would call it a PRO1, but there would be some form of prior written notice or some form that the State Department of Education gives to school districts to use.
And the term prior written notice, this is supposed to be given to a parent prior to anything happening. So any changes made or any agreed upon action, you're supposed to receive this before those changes are made, hence the word prior. So I think although ODE doesn't say it has to be given to a parent in a specified amount of time, I do believe they say a reasonable amount of time. In my opinion, reasonable is definitely within 7 days. I would love to have the day of or day after, because the more time that goes on without that prior written notice, then in my opinion, the more room there is for things to not really take action or be put in place. So always ask for that prior written notice. Always know that they need to be writing one and submitting one to you after a meeting or after a discussion has happened, after an IEP amendment. Anything that occurs, you should have a prior written notice. And that's really your ability to see, again, keep that paper trail of what was discussed. So you can come back to that if you need to and say, well, wait a minute, on this day, we talked about X, Y, and Z, what's happening there. So these are really powerful forms, I do believe, in our arsenal to be able to argue for actions that are not occurring. So next is child find. So this is the obligation of a school district to identify and educate students with disabilities. So any child that lives within the bounds of a school district, that district of residence is obligated to evaluate, identify, and serve students who have disabilities. And sometimes that's a little difficult for students who are open enrolled because district of residence and district of service is different. And so sometimes there's an agreement between the two districts on who's doing the evaluation or who's running the IEP, but that is very case by case and specific. However, the point of child find is if you have a child who has a disability, you have a right to request an evaluation. And if you've made it known to the district that your child has a disability, they need to follow through with that. Whether that is evaluating and having that proper protocol or issuing you a prior written notice and saying we don't suspect a disability. Something has to happen though. I have had a number of cases where parents have made it known their child has a disability, whether it's ADHD, autism, dyslexia, and they've made it known, but the district does nothing with that information. Or they say, well, we will provide interventions, whatever it may be, without actually following through with that protocol. So it's really important for you as a parent to know your right under child find. Again, if you make it known to the district your child has a disability, even if they are not attending that school, if they're in a private school or they are open enrolled somewhere else, make it known to your district that you want your child to be evaluated to be able to see if they qualify for special education services.
That's a good point, Danielle, because I think it's important to know that that does apply child find. So the requirement for school districts to find children with disabilities within the district, it applies to children who are attending private school in the district. So that means that schools that have this obligation, public schools, have to be proactive about finding children with disabilities. They have to work with preschools within the district. They got to work with private schools within the district. They got to take referrals from parents. They got to take referrals from those preschool teachers. So it is an obligation to find children with disabilities and identify and evaluate them. So I think that's a good point. Thank you.
And this applies to homeschool kids. If you are homeschooling your child and you suspect they have a disability, again, your district residence has the right or obligation to identify them if they have a disability. I do find it interesting. So in preschool, you have to, I guess, advertise, if you will, that you evaluate children who have disabilities. Now, whether it's in a newspaper, online, some way you say, hey, if you suspect your child has a disability, bring them on in and we'll assess them. I find that interesting because there really isn't anything like that, in school age. They just expect the teachers to notice something is going on. But in preschool, a lot of preschool, I think every preschool that I know of does have some sort of protocol when it comes to having kids come in who you suspect have a disability. So if you are a parent of a child of preschool age, know that your district is there to assess if you suspect that they have a disability. So last one on the page is RTI, or response to intervention, which is now called MTSS, multi-tiered system of supports. It's the same thing. They just changed the name to make it sound fancy. And what that is it's providing interventions to students who are struggling. It could be academic interventions. It could be behavioral interventions. It could be interventions to target social skill deficits. Anything really that a district can do to sort of come in and try to provide the student with some support, some services. Maybe that student doesn't need special education services at this point in time. What I want to say with RTI and MTSS is the state of Ohio says that you cannot use this to delay an evaluation. So if you truly suspect your child has a disability, the district cannot say, well, let us do our 6 weeks of interventions and then we'll come back to the table and talk about if we suspect a disability. They can't do that. What they should do is start the evaluation process, and while they're doing that process, provide those interventions. But again, I think that's a gray zone, because you may be a parent of a student who is struggling with reading, and they're maybe eligible for Title I, which is a small group reading support, or maybe you have a Wilson trained individual in that school who's going to provide some one-on-one or small group Wilson instruction. And as a parent, maybe you're okay with that. Let's just provide this intervention and see how it goes. But again, an intervention usually is 6 weeks long to be able to see if it's effective. And if it's not, then you talk about, again, do we need to evaluate? Do we need to change the intervention? I think it's really important for parents to be involved in this process, because I see oftentimes they're not, because the school will just do it on their own. But as a parent, be involved, know what's going on, know what's happening, know what progress your child is making, and ask for that progress. Again, part of FERPA is having access to your child's records. So know what is being done with your child and how they're progress monitoring, because that's really important. But again, don't let them snowball you and say, well, we're doing RTI, so we'll wait and see, because the wait and see approach is illegal and unethical. So don't let them do that to you. All right, so moving into some IDEA special education terms. So these can be very confusing for those who don't use them every day. And like I said, I speak the language every day of my life, and I have for probably a decade. So I typically will just spew off these terms and forget that maybe no one knows what I'm talking about. We're going to start with ETR. So this is the evaluation team reports. I believe it used to be called MFE, right? Multi-factor evaluation, a long time ago. But the ETR is the team, the school's team. It's their process of collecting information. So what starts the ETR process is the referral for evaluation, and then that consent that the parent signs to start the evaluation process. Now, a district has 60 days to really come back together and talk about what they found. But the report lays out all that information they collected. So typically you're going to see some testing results that, again, you would have signed consent for in that planning meeting. Some testing results, observations, curriculum-based assessments, maybe some rating scales. But that report is what qualifies your child for special education services, or that maybe you come to the table, you have the ETR meeting, and you determine they're not eligible for services. But you have to have that ETR to go ahead and lead into an IEP, which I'm going to skip down because I just said an IEP. So that's an individualized education program or plan. And that really, again, is individualized, specific to your child's needs, and it feeds off that ETR. So that the information in the ETR, as a parent, I would say, look at the educational needs box and all of your part ones and your summary, because those educational needs have to be addressed in an IEP somewhere. Whether it's noted in the profile that, hey, we've identified a student has trouble with social skills, but at this point in time, we're not working on that. Or it's a goal, or it's an accommodation. Somewhere in the IEP, you have to have that information stated on how you're going to address that. So that's why I said when it feeds into the IEP, because you can't just write you can't just write a writing goal if they didn't qualify for writing in that ETR. You have to have baseline data to have those goals. So the ETR and IEP go hand in hand. Now, if you come to the ETR meeting and you disagree with the findings, then you are able to ask for an independent education evaluation, or an IEE. And this is at the district's expense. So you as a parent do not pay for this evaluation. Now, I would say typically you would be checking the disagree box on the ETR. However, you could check agree in the moment and then decide, you know what, I don't agree with that. And that's okay too. You don't have to disagree with the ETR to request an IEE.
And
an
there's a
IEE
question, Danielle, sorry to interrupt, but we just
you're fine.
got a question in the chat box. It says,
Yep.
Is an IEE also done by the school, or is that done by someone else?
That's done by an outside provider. Now, I will say ESCs are all over Ohio, and it's an educational service center. And educational service centers contract with multiple school districts. Now, I've been in situations where a parent has requested an IEE and they have used a different school site that's a part of that ESC. Now, the school district of residence is still paying for that some way, somehow, when they pay the ESC, but I have seen that. So it would be a different school psychologist. I haven't seen it very often, but I have seen that. But typically, it would be an outside psychologist who would perform that IEE. And you can request one per evaluation. So every time your child has a school-based ETR, you can request an IEE. If you aren't happy with the findings, if you disagree with the findings, I haven't ran into an issue where a school district has denied an IEE for any reason. So again, just know that's your right to request at any point in time. And again, one per ETR.
And one other question that came in was, and how often does the school do an evaluation?
Every 3 years. Now, it can be more often, but it cannot be more frequently than once a year. So it's somewhere between 1 and 3 years. Legally, it's 3 years, but there could be a number of reasons why you would do an early evaluation. It could be if they're transitioning to kindergarten. So a lot of times you have preschool students who transition to kindergarten and they need to be reevaluated because maybe you're looking at a different disability category, maybe things have changed. If you have a new diagnosis that maybe would impact the qualification of the ETR, that would be warranting a new evaluation. Or let's just say you have a first grader and now they're in third grade and they're really struggling. Maybe they were kind of borderline in some things the first go around. So there are definitely situations where you would do an earlier ETR, but again, it can't be more than once a year. And it has to be both the district and the parent agreeing to do an early evaluation, but every 3 years legally. Okay, so next is the FBA, or Functional Behavior Assessment. And the FBA leads into a BIP, which is a BIP, or a Behavior Intervention Plan. So very much like an ETR feeds into an IEP, and the FBA feeds into a BIP. You can't really have one without the other. And so the Functional Behavior Assessment, if you have a student who is really struggling with a particular behavior, and you and the team are left wondering why is this behavior occurring? What is going on? This is when you would ask for an FBA. And FBAs, from what I have found, the timelines are not as strict as an ETR, but just kind of like 504s, they kind of fall back on the IDEA timeline. So a lot of times with an FBA, you would still have very similar timelines. So consent, and about 60 days later, you're going to come back to the table and talk about the FBA. Now the FBA, I'm not going to say anybody can do an FBA, but you can have a school psychologist do the FBA. You could have a mental health counselor or therapist do an FBA. You can have a behavior specialist, a BCBA, which is a board certified behavior analyst. It could be a number of people, but you just want someone who's trained in behavior and recognizing behavior and understanding behavior, who can write that FBA. As a parent, you can't necessarily request a BCBA. I mean, you can. I should stop saying you can't. You can, right? You can make a request about anything. But the district could say, well, we don't have a BCBA, but we have this individual who's trained to do that. And in my opinion, that would likely be sufficient to collect the data you want to collect, because that's what really an FBA is. It's data collection. And so, yeah.
Yeah, I think it's important too, because you've just talked about ETR and IEP and explained how that the ETR drives the IEP and the ETR is the data. that you use and the assessments that you use to come up with the plan, the IEP. I think it's important to point out that the FBA is also an assessment. It's just an assessment specifically for behavior, which will drive what's called a BIP, a behavior intervention plan. We don't have on here, but you've mentioned a couple times. So, the assessment or the evaluation drives the plan. So here, the FBA drives the BIP, or the ETR drives the IEP. And those are, basic terms, but basic understanding too, but I think important to point out and highlight.
Yeah, and you really shouldn't have a behavior plan without an FBA because, again, they feed into one another. And the functional behavior assessment is a really great tool, again, when you have concerning behaviors and you want to figure out what's happening before the behavior, or even what does the behavior look like? The intensity, the frequency, the duration, all of those key terms are in the FBA. And like Mark had said, it's a data collection tool. So it's being able to collect all that data. And don't be shy to ask for an FBA. Don't be shy to ask your district to do one of these assessments because it can be an extremely valuable tool to really come in and focus on the behavior and write that behavior plan to be able to address the behavior. Now, something I've ran into. So again, with the FBA and BIP, not as stringent with timelines as the ETR and IEP. So unlike an IEP where you're going to get progress reports every 9 weeks or so, a BIP doesn't have that stipulation. So you're not necessarily going to get specific progress reporting information from that BIP. You're going to meet on the BIP annually like you do on the IEP. So typically you'll have a meeting to talk about both those documents. But as a parent, request that data for the BIP or check in and say, hey, how's it going? Are we still implementing these things? Because I do think the BIP gets lost in the shuffle, especially when you have an IEP that people are focusing on. So don't let it fall back into the darkness where no one is implementing it, no one is monitoring it. But I unfortunately do see that happen quite often. So SDI, or specially designed instruction, that's what's on the IEP. So when you have an ETR meeting, one of those boxes you check is, does your child require a specially designed instruction? And if you say yes, it qualifies them for the IEP. And this in section 7 is what spells out, what does that look like? What is being done differently for your child versus a typical child? I don't like seeing vague information on this section 7. I see it all the time, especially design services and reading. What does that mean? So make sure it's spelled out what exactly is being done to help your child be successful to target that goal, because that's going to help. Again, you just understand what's happening in the school setting. It's going to help you understand that progress when your progress reports come home, knowing what's really occurring in the school setting. So that special design instruction will target those goals. Now, related services are related to the services that are being provided. They are related service providers. So your speech, your OT, your PT. Sometimes you'll see a school psychologist or a mental health professional. Those are all related service providers. There are probably more, but those are the ones that I typically see on an IEP. And they are also providing services through a goal of some sort. It may be attached to someone else's goal. Sometimes you'll see like a writing goal where you'll have the OT working on some handwriting and the intervention specialist working on maybe the writing, the grammar and the context. But those individuals are on that section 7. Now, something about SDI is they have to say how much time they're devoting to that goal and where that service is taking place. So the location of service. When it comes to the time, there's no specific time that ODE or IDEA would say is an adequate or an appropriate amount of time. This is very much up to the team to discuss and decide on. Sometimes I do think school districts just pull a number out of thin air and stick it on the paper, and that's what we go with. But remember, this is the amount of time that goal is being worked on. It may not equate to the amount of time that the student is in the resource room working on reading. This is just the amount of time focusing on that goal. But if you ever feel like the minutes are too low, then argue that point and ask for them to increase the minutes. If you feel like my child is being pulled out way too much, they don't need all that time, then of course you can argue for them to be decreased. But I do think this is the point that we talk about a lot in meetings, because There is no, it's very gray again, no black and white solution to those minutes. And I see you have a question.
Yeah. The question is, with all of the deadlines called for in the various plans and forms, how well generally do schools comply with the deadlines? And how strictly do courts enforce these deadlines? I'll start with my opinion. First of all, the rules are technically broken all the time. Unfortunately, it is, the obligations on schools are hefty, with especially with timelines, the requirement for schools to, identify what the progress is, to evaluate in a certain amount of time on all the areas, all the potential deficits that were requested. It happens all the time that there are technical violations of IDEA, and there are enforcement mechanisms through state complaints and due process complaints. Those are administrative complaints to the Department of Education, where you, with the due process, with the state complaint or due process complaint, you're assigned a hearing officer to hear the issue. So there are enforcement mechanisms that way in due process to require schools to follow those. Now, you would waste a lot of time, money, and energy if you filed a complaint every time a school, was a little bit late on providing a progress report, or didn't give you a prior written notice, on what you thought was a timely fashion, or at all. And Danielle mentioned one that happens pretty frequently, which is doing a behavior plan without a functional behavior assessment, which seems backwards, but it happens. It's a very good question, because it is hefty obligations on schools, but there are times where you're just going to have to, encourage school to get it done, identify what their obligation is, and do it in a way that's, actually meaningful and will practically, get you to where you want to go. But if it is a substantive violation, courts will absolutely enforce it. The good thing about IDEA is it's statutory, and there is some good guidance through the statute and the regulations. So you can really get to the rule and identify where a school has messed up, and it's pretty black and white. A lot of times it ends up in mediation. You can resolve it there or through the administrative process. These cases do end up in court, and either the administrative hearing officer or the courts will absolutely enforce the deadlines.
Yeah, I will say I haven't seen many where the ATR and IEP themselves are out of compliance with timelines. I have seen a few, but I would say typically it's like the lesser known timelines, like Mark said, the progress reports, the prior written notice, IEP amendments, because there's a deadline on amendments. But for instance, I have a case right now where we were supposed to meet 2 weeks ago to do this amendment, and it got canceled and hasn't been rescheduled yet. We're sitting here in November. And so, you want to make sure that the services are being provided. And so that's always my argument to a parent. Maybe not get hung up that the IEP is a week late. If those services were still being provided, then in my opinion, maybe not worth the fuss.
Yeah.
I've been in meetings where they ask us to sign and they have a different date. And I questioned that. Is that because it was due last week? Okay. It doesn't happen very often, but it does happen. So I would say, unless your child is missing out on services or supports because of those timeline delays, otherwise I would let it go, in my opinion.
Another good example is sometimes a team member, the IEP team, can't make it for some reason. So maybe the general education teacher can't make it, or maybe even the special education teacher or the school representative can't make it for some reason to the meeting. That's a technical violation. And sometimes that interrupts, what's happening at the meeting. We need that person's opinion and or authority. So, but sometimes you got to let that go too. They're supposed to be, excused by the parent or student if they're not there. But that's kind of a technical violation that you have to make a judgment call about on whether it was, necessary to file a complaint or push it. One where it might be absolutely necessary to, file a complaint when you're talking about whether, just what Danielle said, whether the services are being provided to the extent that they say they're going to be provided on the IEP. Are all the minutes there? Or, if it says we're using a BCBA, are we using a BCBA? Is therapy being provided for 30 minutes, twice a week? Those are the types of things that are very substantive. And if they don't fix it, through I guess, informal means or maybe mediation means, then absolutely, time to exercise your due process, I guess.
Mhm.
Good
Agreed.
question.
So assistive technology, this is something else that is on the IEP when it comes to, assessing your child's ability to access the curriculum and if they need additional, support through technology. Now, assistive technology, there's a box in section 2, and you can check yes or no if they need assistive technology. And sometimes I see it checked, sometimes I don't. But if it's checked, then in that section 7 under assistive tech, which it might be, it's hard. Oh, there it is. Okay, under related services. There should be stated there what is being used. Now, I remember as a school psychologist going through my training, and we were told, even a pencil grip is assistive tech. An elevated surface for reading is considered assistive tech. And I should have pulled up the definition. I don't have it in front of me. But if you look at the definition of assistive tech, it is very broad. I'm not sure why they chose the term technology, because we hear that, we think computer or electronic device. But really, it's anything that the child is using, any device, any physical resource that they're using that is different from a typical child, and they need that device or support to access the curriculum.
Would you think like a calming chair would fall into that category?
I don't know. I should.
I'm sorry to put you on the spot. I don't know.
I haven't really seen it on there. I will say, like sensory supports, for instance, I haven't seen that on there. But yeah, why is a pencil grip considered AT? I'm not sure. Yeah. But yeah, so I think a lot of school districts honestly don't know what to put in this box, or don't know if something is in that box, so they won't put it in there. They'll put it in the accommodation section. And again, I'm not picky. If it's in the IEP somewhere, it's in the IEP somewhere. And so if they decide to put it in the accommodation section, which I see that a lot, like, I know now a lot of districts are 1-to-1 with their laptops or Chromebooks, but before they were, having a personal Chromebook that may be in the accommodation section instead of AT. And again, I'm not going to fight that, it's in there somewhere. Yeah. But on the each year planning form, there is a box linked to the very bottom that is assistive technology assessment. And I don't know if a lot of parents know that's on there, but as a parent, you can request an AT evaluation. And some districts do have their own people on staff. Some don't. They need to talk to the state support team or ESC to get somebody in. But as a person who's been involved in those assessments, it is very thorough. It's really, sitting down one-on-one with that child and looking at their ability to access technology and use technology, interviewing them on what they use at home or what they think has been helpful to them, and then trialing things. It could be a lot of different, again, devices. You're talking about like a communication device. Maybe you're trialing some devices to see what works. Maybe you're looking at different apps or different online programs to use for a child. But that individual, if you put on the planning form, they're going to have that individual come in and do that assessment and look at what your child needs. So I don't request it a lot, honestly. I don't see requested a lot by parents either. But just know that is your right to request an AT evaluation if you feel like that your child would benefit from or needs some AT devices.
And Danielle, since we're on this slide, I'll point out something. We got a question on this another time we did the workshop, but under the section 7, we're showing an example here of specially designed instruction and related services, and AT and accommodation, and so on. Those boxes expand. So these aren't limited to one piece of specially designed instruction or related service. And so you just add lines as you need them. You'll see this with section 6 and the goals too. The goals on the IEP, the form may have, one line in there, but it's expansive so that you can add goals. You may have 3, 4, 5 goals. That's a lot, but for a child, but because the form looks this way.
I've seen like 7, 8 goals, Mark. 4 or 5 is not a lot of goals.
I know I can't work on 7 things at a time. That's for sure.
That's why we have a lot of different people, right? A lot of different people working on those goals.
But yeah, I thought that was a good question our last time we did this. So I wanted to point that out.
Yeah, absolutely. And the IEP training we have is a really great training where we go piece by piece on that. So look for that to come. So next is the 504 plan. So Mark had talked about the section 504 in the law section. So the 504 plan is a plan for accommodations made under section 504. Now, again, you should have an evaluation to qualify for a 504 plan. I see that very rarely. A lot of times the school district will say, okay, you told me your child has, we'll just say ADHD. Fantastic. We're going to run a 504 plan to provide them some accommodations. But really, even the law would support the fact that you need an evaluation to qualify for the 504 plan, because if you don't evaluate, then you aren't going to be able to really see that what that child needs. You're just going to come to the table and give them maybe generic accommodations or just assume what they might benefit from. So there should be an evaluation. Also, the law does say that you should rule out the need for special education prior to writing a 504 plan. So really, in my opinion, if you have a child with a disability, and maybe you're even wondering, I don't know, did they just need a 504? Do they need an IEP? Ask for the full ETR, because at that ETR meeting in section 4, when you talk about qualifications, you may say, you know what, they have a disability, but they don't need specially designed instruction, so let's write a 504. And that serves as your 504 evaluation, then to write your 504 plan. I just get really irritated when I don't see that happening, when a district just wants to go straight to a 504. And I'm making some assumptions. I think a lot of times districts do it because a 504 is not monitored like an IEP is monitored. You may have a 504 that it just repeats itself every year. They get the same accommodations every year, and no one's looking at this. No one is making sure it's being implemented. You don't get any progress reports. So a 504 is just very lenient, I think. And a lot of these monitoring, monitoring tools, if you will, that we get with an IEP. And so I think sometimes districts just want to go to a 504 because it's easier.
I think that's a good point. I mentioned a couple things with state complaint. When you have an IEP and there are violations that are substantive, it might be worthwhile files. Get a mediator, which are free from the Department of Education, to help resolve the issue. File a state complaint, file due process, which is a full hearing, basically a full trial, which the parent doesn't have to pay for other than their counsel. And then, but with the 504 plan, if there's a violation, there's no administrative remedy in that way. You can identify that you think there's a violation to the school, but it's resolved internally with the school if they resolve it. But if not, the next step would be filing a complaint in state or federal court, which is most parents aren't going to take that step. So you're right, Danielle, the procedural safeguards are not in place for a 504 plan. And you mentioned this is a plan for accommodations. I think it might be helpful, because with an IEP, we're talking about special education or specially designed instruction for a student. So if the student requires special education, they should be placed on an IEP. So tell us what an accommodation is. So what would a 504 plan have on it? Which is something less than special education.
Right, an accommodation, which on an IEP, you have that accommodation section. So an accommodation is to level the playing field, if you will, to allow your child to access the curriculum or the school environment. And so a 504 accommodation can be extended time for tests and quizzes, small group testing, one-on-one testing perhaps. You can put related services on a 504 plan. So if your child needs OT for sensory supports or OT for fine motor supports, even speech can be on a 504 plan. The school does not get reimbursed for those services, so they're very hesitant to do so. But if your child qualifies for speech, OT, or PT when it comes to accommodations, that provider can be on that 504 plan. It could be, I'm trying to think, I'm blanking now. I don't know, guided notes, for instance. A teacher may give your child guided notes, so your child doesn't have to take all those notes. But I would say they're pretty, rote. Again, most kids have like the same accommodations, so it's not individualized necessarily.
Yeah, I think it's an important point you made too, that there is an accommodation section. Let me get there here. In section 7 of the IEP. So, you can add accommodations to the IEP too. And although it's accurate to say you could be on a 504 plan and an IEP, it's redundant because there is an accommodations. The 504 plan of accommodations could be simply just included here in the accommodations section of the IEP. So those, just because you have an IEP doesn't mean you don't have access or a way to record the accommodations. And if the accommodations are on the IEP, guess what? Now they're your due process rights and right to complain, and procedural due process is much stronger because it is on the IEP.
Right. Yeah. And anything that's in a 504 can be on an IEP. If you have a child who has diabetes and needs frequent blood sugar, monitoring or whatever, maybe that can be on an IEP and there's support for medical services. So yes, anything can be on that IEP that's on a 504. But like I said, make sure you ask for that evaluation. And you may just think your child needs a 504 plan, and that would be perfectly fine. Make sure you ask for that evaluation. Because I do think that's important. I think it's important to collect information from your child's teachers, to include any medical information or background information, health information that a parent might be able to provide. Sometimes if I had a child who had ADHD, I would do some behavior rating scales because I would want to see really what's going on so we can have more targeted accommodations, because even though individualized is not in the 504 name, it still should be individualized. It should not be just a copy and paste from the kid who had one yesterday. So important to note. And then lastly is the manifestation determination review. And I'm going to let Mark describe that a little bit further.
Yeah, sure. So manifestation, this is also known as an MDR very commonly. And so children who have an IEP, so students on an IEP, generally speaking, can be disciplined in the same way as other students. So, if you violate a school rule and you're suspended, you're held to the same account largely as other students. However, there is a limitation on that for school's ability to remove a student on an IEP from the school environment. So if the suspension, let's say and we're talking about out of school suspensions here, or expulsions, if the suspension is more than 10 consecutive days, then the school has to consider whether or not the behavior in question was a manifestation of the child's disability. So if you're acting that way because of your disability, or because of a behavior that is manifesting itself because of your disability, then of course the student shouldn't be punished in some way or removed from the school environment. So they go through this meeting, this review, MDR, to say, okay, what was the behavior in question? What's the disability? Could it have any overlap? So, ADHD sometimes has a impulsivity component. So if the child pushed somebody and that kid happened to fall and hit their head or be injured in some way, and that the student was ultimately disciplined for that, but they found that, okay, well, it may have been related to his impulsivity, or may have been related to his sugar levels, or lots of different things that could be a manifestation of a disability. If they determine that it was, then the student, then if it hasn't been done already, then you have to do a functional behavior assessment and see about implementing a behavior intervention plan. And the student cannot be suspended or expelled beyond that 10-day point. There's another caveat to that, is that even before 10 days, if the behavior is repeating, so the student's getting in trouble for the same things over and over, and let's say they're issuing 1-day suspensions at a time, if there's a repeating behavior that keeps occurring, then the manifestation determination review should be done, even if it's before 10 days. Or if it's independent days that the student's suspended, but the cumulative total is more than 10 days, then you have to do the MDR. So it's a protection so that students aren't punished and removed from the school environment because they're acting in a way that is a manifestation of their disability. So that's the last thing on the list there. Very important protection.
Mark, the MDR also applies to students who have 504 plans, correct?
Yeah, that's right. Yep. So if it again is an action that is caused, because with the 504 plan, you're still identifying a disability. The difference is the disability on a 504 plan is broader. The definition of disability is broader. So you may have a disability under a 504 plan, but not require special education. You just require accommodations. So you're right, Danielle, it's a good point that the MDR still has to be done if the behavior in question was a manifestation of that child's disability and they're on a 504 plan. So very important point. So that brings us to the end. We're just a few minutes over. This was again the first in the series, Learning the Language. Danielle referenced earlier in the workshop that our number 2 is walk through sections of the IEP. That's a really good one if you get a chance to attend or watch it online. And I should also point out that recordings of these workshops will be online at the link I provided earlier. Let's see. Yeah, there it is. lawyersforstudents.com/legal clinic. So what's upcoming, the descriptions of the workshops, and then the recordings, just like this one, will be available anytime you want to watch them. And first want to thank Danielle. Great, I learned a couple things. I appreciate you coming today.
Absolutely.
And I forgot to say at the beginning, thanks to our interns, we have a group of, I think, 18 different interns that helped us out in getting the clinic started this summer, and we appreciate their input. A lot of them are on the workshop, and we appreciate, of course, the partnership with DRO and OCECD. And we hope to see you at the next workshop, second Saturdays, walk through sections of the IEP. Thanks, Danielle.
Thank you so much.